Welcome everyone. Today, let's take a psychiatric exam. I'm Anthony Ray, one of the attorneys here at Ray Law Criminal Defense, where we believe it is critical to educate all on the legal impact of their actions. If you are new here, make sure you click that subscribe button and check out the links below. Let's take a look at the law, the legal procedure, and the facts for today. On August 6, a teenager is alleged to have carjacked a man's pickup truck at gunpoint at a gas station in Ferndale. The teenager was pursued by the police. The police eventually forced the teenager to stop the vehicle. When the teenager stopped the vehicle, he locked the doors and refused to get out of the pickup truck. At this point, the police broke the window of the vehicle and pulled the teenager out of the vehicle. The teenager is being charged with armed robbery, carjacking, and fleeing and eluding the police. There is a lot to unpack here, but what is more interesting about this case is that the judge in this case has granted the teenager's request to use mental health defense, or more commonly known as the insanity defense. In Michigan, a person cannot be responsible for their actions if at the time they committed the crime, they were struggling with mental illness. In Michigan, the mental health defense can be used if the person is unable to understand that his or her action was criminal, or second, unable to follow the law. There are certain procedural requirements that must be followed if you intend to assert a mental health defense. First, the court and prosecutor must be notified that you intend on using the defense. Then, the court must then determine whether the person should undergo a mandatory psychiatric evaluation. It must also be proven based on a more likely than not standard that a person meets the requirements necessary for a mental health defense. In order for a court to approve a mental health defense, the mental illness must be severe, such as schizophrenia. In this case, the teenager's attorney was able to persuade the judge that the teenager, more likely than not, has a mental illness, and that the mental illness prevented him from understanding that his conduct was criminal. Even after the teenager secures the judge's approval for moving forward with the mental illness defense, the teenager's attorney must be able to demonstrate that the teenager should not be responsible for his criminal conduct because of his mental health. The judge or jury must be persuaded. It is important to note that even if the teenager is acquitted of the crimes based on a mental health defense, it does not mean he simply gets up and walks away and resumes normal life. The judge will order that the teenager undergo psychiatric assistance. This can include confinement to a mental institution. Now, more than ever, it is important that you have a criminal defense attorney involved in your immigration case to fight and protect your rights. Get the Ray Law advantage. Get the protection and knowledge you need to get your life back on the right track. Thanks for watching. We'll see you next time.